moving into separation of powers. Now, there's different issues within separation of powers, but the three big areas, and these are probably areas that you have actually done tons of in college, particularly if you were in UCD, because John loved separation of powers. So you've actually probably got a huge body of notes within your UCD lecture material that you can draw on for any of this, okay? And the concern I have about separation of powers is that really John has been quite limited in what he's examined. He's examined delegated legislation a good bit, okay? You'll see it's on the overview I gave you. He's examined once the power to sentence, and he's examined recently cabinet confidentiality and Oireachtas privilege, which comes in here as well. So he's been quite limited in what he's examined. I mean, I can't really see him putting delegated legislation on again, having examined it 3 times. So from that perspective, I think he might go more towards the executive or the judicial side of separation of powers. Now, that's only me guessing. He's perfectly entitled to put delegated legislation on again if he wants. Now, what I would say to you, however, is my concern with separation of powers is that if he puts a whole question on delegated legislation, that is 1 hour of an answer and he expects a good answer. This is where articles really come in, okay? Because what he wants you to do is to challenge the way that the separation of powers principle is being applied or is operating, okay? Whether it is he asks you to hone in on delegated legislation or whether he asks you to hone in on an aspect of the judiciary, okay? Now, as I outlined, it is possible he'd give you a general statement question on separation of powers, that it's an important check and balance within the constitutional system that ensures the smooth running of a democracy. He could give you a general over question like that, in which case you actually have to discuss each of the 3 aspects of separation of powers, and I'm assuming you all know there are 3 aspects to separation of powers. But what he has tended to do, and the more likely approach he adopts, is he hones in on one aspect, okay? Which means that far greater amount of information is needed if you've got to do a 1 hour answer on delegated legislation than if you have 1 hour to discuss a bit of delegation, a bit of executive and a bit of judicial. Okay, so what I'm going to do is we're going to go through it, and in areas where John hasn't examined it, I'm going to actually maybe throw out possibilities of the way that topic would come up. And what I'd like you to do is write it in wherever I'm talking in the manual, so that when you come back to look over it, in the back of your mind, you have, because there are only certain ways things can be examined. So John mightn't use the exact same words as me, but he'd essentially be examining the same thing. And it's particularly important that I do that for you in areas of separation of powers that haven't come up on the paper before, so that you get some sort of handle on how this would appear. So we're going to take a look first of all. Now, one of the big things we're looking at here first of all is to do with the executive power. Okay, now he's never examined the executive power before, so from that perspective I actually think it's very important. Now, we'll be looking at how executive interlinks with the other 2 powers in a minute. So what we're just looking at here is executive power on its own, okay? Not how it links up with the other 2 powers or overlaps with the other 2 powers. Now, you can take a look at the manual here, 203 we're at, paragraph 203. And you'll see that one of the biggest difficulty with the executive power is that the Constitution, it indicates that we're at the issue at the beginning of the paragraph, it indicates that the executive is subordinate to the legislature, okay, and we all know the executive is drawn out of the legislature, we all know that, yep. So, but what it doesn't do is, it doesn't actually give us a clear understanding of what the executive power is, okay. We've got some guidance. Article 29.4 says, gives the power of the state in relation to international relations and foreign affairs to the government. So that clearly must be an intention to be an executive power. So our power in terms of international relations and foreign affairs is assumed, or is said within the Constitution, to be an executive power. Similarly, the decision in relation to the Special Criminal Court, Article 38.3, and when the ordinary courts aren't adequate and the Special Criminal Court needs to come into play, that is similarly vested in the executive under the Constitution, so we can therefore assume it's an executive power. But we don't have any actual definition. And when you come to see legislative power, you'll see we get a general definition. When we come to judicial power, we similarly get a general definition, but we don't get that with the executive power. So it nearly is default power. It definitely is those 2, and then really it's anything else that doesn't fall into the legislature or doesn't fall into the judiciary. Okay, now a type of question I think could come up, and if you want to scribble it down at the end of your book there, is it somewhat links in with the study focus, would be, with the reluctance of the court, which we're going to look at in a minute, to intervene in the exercise of an executive power. So with the reluctance of the courts to intervene in the exercise of an executive power, the lack of a clear definition of what is an executive power is worrying, or is unhelpful, whatever. John mightn't be as upset about it as I am. Okay? The lack of a clear definition of what is an executive power is worrying or unhelpful, something like that. Yep. With the reluctance of the courts to intervene in the exercise of an executive power, the lack of a clear definition of what is an executive power is worrying or unhelpful. Okay, and what that is asking you to cover is, it's asking you to cover, and we're going to go through them, all the examples of where the courts have said, based on separation of powers, that's an executive power matter, it's within the domain of the government, we have no power to intervene. Sometimes they do give some limited circumstance where they will intervene, okay? But the difficulty is that because we don't, it also examines the fact that we don't have a proper definition of what is an executive power. So really it's on a nearly a case-by-case basis the court are having to say, well actually, this is an executive power, and because of separation of powers, we're not taking a look at it. So it's difficult for a litigant often to go into court and say, well, look, are they going to hold that this is an executive power, in which case it was fine for the government to take care of it, because we don't have an actual concrete definition that a legal advisor can use in advance to tell their client on the likelihood of whether that power would be held to be executive or not. Okay, we're going to see it now. But this is huge in the whole area of participation in a war, okay? So it'll become more real to you in a minute. Everyone okay? So we're going to look at some general principles first of all. And if you look at the first paragraph 205, what you'll see here is that courts basically take the view that there are certain matters that are the function of the executive, and you'll see you're given examples here. And the courts will be deferential or will be reluctant to judicially review such a power, okay, because they'll consider it to be a political matter which is not within their competence, okay. Now, 2006, paragraph 206 tells you up front what the general rule is, okay? And look into the second line. At best, it tends to amount to a view, this being the view of the court, that the executive is not free from constitutional fetter or constitutional restraint, but that in cases where matters come within the general area of the ill-defined executive power, the courts will intervene only where there is a clear disregard of the Constitution. So we're going to take a look now at cases where somebody has argued that the government have acted in breach of the Constitution. The court has, first of all, had to have a look and see, well, is this in fact an executive power? If it is, it was right for the court or for the government to be exercising it. And then they've had to look at the second issue of is, okay, if it is an executive power and one which the courts, or which the executive, not the courts, should be determining, then has there been a clear disregard of the Constitution? Because that's the only time we're going to intervene with the executive and say, sorry, you are wrong on that policy. Does everyone understand? Okay, first one is Dudley. And this had to do with, now note, it's an electoral act, so it was a piece of legislation. And what happened here is the facts are given to you in 2007, so I'm not going to repeat it to you, I'm not going to read it out to you, you can look at it yourself. What happened was he basically had a vacancy had occurred in membership of the Dáil, so there needed to be a by-election. That electoral act outlined the procedure that needed to be followed in order for this by-election to be called. The procedure wasn't followed, just delayed, and the seat was vacant for 14 months. And a student, who obviously had nothing better to do, living in the constituency, decided to argue that the government were in breach of their constitutional obligation to, by not calling this by-election within a reasonable time. Okay? Now, what the quotation does there, first of all, is the court outlines that they do actually believe that there was an arguable case that the government had a constitutional obligation to enable a by-election to be held after a reasonable time. Okay? Now remember, the whole procedure for the calling of a by-election is not laid out in the Constitution. It stems from this electoral act, a piece of legislation. However, the court was willing to believe that within the government's duties under the Constitution, included in that, it could be argued,